The Northern Ireland Human Rights Commission was established under the Good Friday Agreement. Its mandate, as defined by law in the United Nations, is to protect the human rights of every person within Northern Ireland. But what is the impact when an individual within that system is alleged to have unilaterally prevented a case from being heard? This is an investigation into an obstruction of justice, a senior official named David Russell, and questions about whether the Commission's own processes may have failed. I'm your host, Kiana Canada, and this is an investigative series. My reporting centers on a specific case, mine, which was submitted to the Commission in 2023. The case involved government overreach, intrusive surveillance, and degrading treatment and punishment. According to the Commission's own published criteria, which can be viewed in the description box below, this case fell squarely within its statutory mandate. The initial submission was acknowledged. Then, for more than 2 years, the case remained in administrative limbo. Dozens of emails and phone calls documented within this timeline were altered and intercepted. But by who? The official responsible for managing this pre-screening process was David Russell, a senior executive at the Commission. His role, as we understand it, is to assess cases and prepare them for the commissioners, the independent appointed board that makes the final decision. In this instance, that preparation never happened. The case never reached the commissioners. And this raises an important question about an external influence. During this 2-year period, I obtained information leading to a strong presumption that David Russell's handling of this file was not merely a bureaucratic oversight, but was influenced by an external actor. My research points to an instruction from a high-ranking official with connections to the PSNI, the Police Service of Northern Ireland. The nature of this instruction was to ensure the case did not progress. Who is this authority figure? And more importantly, why is the Commission concealing their identity? According to sources, this official has significant international liaison connections, including to agencies both within the United States and the Republic of Ireland. The implication here is that my case had dimensions that attracted both external and transnational interest. But for who? I have put these specific allegations to both the police ombudsman and the Commission. And at the time of this broadcast, there has been no thorough or adequate investigation by the Commission into this authority figure or the PSNI's human rights violations. And this leads us to examine the framework that should have prevented such violations from occurring in the first place, the Paris Principles. The principle, be competent to protect. The rule, a national institution must be vested with the competence to promote and protect human rights. It must be effective in practice, not just on paper. My reality. I came to the Commission with specific serious claims under the Human Rights Act, including an Article 3 violation to be free from degrading treatment and punishment, Article 8, the right to privacy, Article 10, freedom of expression, Article 14, the right to non-discrimination, and Article 2 of Protocol 1, the right to education. The violation, making me wait outside and then ignoring my claim, wasn't just degrading treatment. It was the fundamental failure of its reason for existing. A body that doesn't listen to ordinary people alleging such a broad range of human rights violations isn't protecting rights. It's protecting a system that is violating them. Its competence became a hollow legal term, not a living reality. The principle, a broad mandate, narrowly applied. The rule, the Commission's mandate is broad, clearly set out in law to cover the entire spectrum of human rights. We know that to be sure, but here's my reality. The Commission has the power, and this is from what I understand, to review the adequacy and effectiveness of human rights in practice in Northern Ireland. My case, touching on everything from the right to education to protection from discrimination, was a legitimate test of that practice. But here's the violation. By keeping me waiting outside and then turning me away, the Commission arbitrarily shrank its own mandate. And not only that, it acted as a gatekeeper and determined that my fundamental right to education and my claim of non-discrimination wasn't worth its time. Why? This contradicts the very idea of a broad mandate, which is designed to be inclusive. I became one of those people left outside, both literally and figuratively. The broken responsibilities of the Commission is important to review as well. It's a point-by-point failure. And this is where the breakdown becomes more clear. The Paris Principles list specific jobs for a Human Rights Commission. And if it's okay with you, we'll see how the Commission measures up. Failure to investigate. The Principles grants the power to hear a matter without higher referral. And this is crucial. It means that the Commission can act on its own initiative. But when it refused to even properly hear my case after making me wait outside, what it did was it neutralized this power. How can they advise the government on protecting our rights if they won't listen, not only to myself, but to citizens when they bring human rights violations to the Commission? Now, failure to uphold the law. My allegations were about human rights that were violated under the Human Rights Act, and the Commission has a duty to ensure that these laws are implemented. Now, there are concerns when it comes to lack of financial resources, but that's not an excuse. And by dismissing me and making me wait outside, they became an obstacle to justice. There are some unanswered questions that I still have that has not been answered. And it raises fundamental questions that require answers from an independent human rights body outside of Northern Ireland. First, what internal controls exist at the Commission to prevent a single official from indefinitely delaying a case that meets its criteria? Two, has the Commission conducted an internal review regarding the possibility of financial incentives? Third, what protocols are in place to document and manage interactions between the Commission's staff and third-party agencies or persons as it relates to an active case? Fourth, why is the Commission preventing the United Nations from learning about and hearing about human rights violations in greater detail? Now, that's an important one. This report is not it's not a conclusion. It is an evidence-based account that reveals a potential vulnerability in Northern Ireland's human rights architecture. The integrity of any protective institution depends on its ability to self-correct and be transparent when its processes are called into question. Until sufficient answers are provided, a shadow hangs over this process. And the people at the Commission which it was designed to serve, are left with just a single troubling question. It's a single troubling question that I had. Is the commission a defender of human rights, or is it a violator?